I'm thinking about bankruptcy. Do I have to sell my house and car if I file for bankruptcy? I often get asked if the court will take a car or house as part of the bankruptcy process. The answer depends on your situation and what exemptions you use on your bankruptcy schedules. When you file for bankruptcy, your attorney will discuss your assets and indicate on your schedules that some or all of your assets are exempt. Exempt assets are those that you generally get to keep and will not be sold for the benefit of your creditors. Assets that you owe more on than they are worth, like many underwater houses and cars these days, will not be sold by the court. The reason for that is that your creditors would not receive anything if those assets were sold, because all the sale proceeds would have to go back to the mortgage company or the lender. There is a difference in how assets are looked at between Chapter 7 and Chapter 13. Since Chapter 7 is technically a liquidation, the trustee is paid based on assets that he finds that he's able to sell, because they are not exempt. He then receives a percentage of the proceeds from the sale before distributing the rest to your unsecured creditors. So the trustee's incentive to sell things is based on the fact that he gets a percentage from it. If there's no equity in an asset, the Chapter 7 trustee will not be interested in it because there's no money in it for him. In a Chapter 13, the trustee is based on your monthly plan payments. She receives a cut of each of your payments throughout the 3 to 5 year plan. Her office makes sure that your plan meets all of the requirements of the Bankruptcy Code, and then lets the judge know if she recommends that the plan be confirmed. You are often able to keep non-exempt assets in a Chapter 13, as long as your unsecured creditors receive as much as they would have if you liquidated the asset. The plan meets the requirements of the Bankruptcy Code. For example, say you have a vehicle that's not exempt and it's worth $10,000. You would then have to pay back $10,000 to your unsecured creditors throughout your 3 to 5 year plan in order to keep that asset. So what can you keep in California? There are 2 separate sets of exemptions used in California. One set is for someone who has equity in their principal residence and doesn't get used very often these days. The other set is for someone with no equity, either because they rent or because the house is underwater. If there is no equity, you have $23,250 in exemptions that you can use for anything, called the wild card. So technically, you could file for bankruptcy and have $23,250 in cash in the bank and still keep all of your cash. You also have $3,525 for a vehicle under this set of exemptions. If you own your vehicle free and clear, you might have to use some of your wild card exemption to make sure that the entire vehicle is exempt. If your vehicle is upside down, then you do not need to exempt it at all because it's not worth anything to your estate. There are many other exemptions, and I encourage you to speak with an attorney about which set of exemptions you should use and why. I have observed many cases in court where the wrong exemptions were used, and the debtors ended up having to pay a lot of money to keep their assets, or the assets were sold by the trustee. I'm glad you joined us today. Please contact me if you have any further questions.